Hi, my name is Tony Domenico, and I'm a partner and co-chair of Fasken's Competition Marketing and Foreign Investment Group. And I am joined here today by my partner, Andrew House, who is also a partner at Fasken and co-chair of Fasken's National Security Group. Hey, Andrew.
Hey, Tony.
So a brief word about Fasken and Andrew. Fasken is a leading Canadian law firm with offices across Canada. We practice all aspects of competition law, marketing, and consumer protection, as well as foreign investment and national security. Now, Andrew practices in the areas of foreign investment, government relations, and political law with a focus on national security. And Andrew is also the former chief of staff to two successive ministers of public safety and emergency preparedness for the federal government. So why don't I, Andrew, maybe just level set our discussion before we get started? So as you know, Canada has traditionally welcomed foreign direct investment, seeing it as an opportunity to create opportunities, stimulate economic development, and introduce new ideas and innovation to Canada. However, recently, the Government of Canada has also demonstrated an enhanced scrutiny of foreign investment in Canadian businesses, having particular regard to national security. We've seen ordered divestments of completed transactions, and more recently, we now have Bill C-34, which received royal assent. And as you know, the National Security Review on Instruments Modernization Act represents the most significant amendments we've had to our Investment Canada Act since the introduction of national security provisions in Canada back in 2009. So with that context in mind, let's go back to first principles for a moment. Talk to me about the concept of national security generally in Canada. It has no definition that I can see in our laws. So how could it impact our businesses and individuals so profoundly?
So this really is the issue that we've grappled with in this country for so long. We do depend on foreign direct investment. It's vital. We have one of the largest geographies on Earth amongst countries, and we have a relatively modest population versus that geography. Our population is spread out, doing things like infrastructure construction, ensuring that people have the goods and services that they need, especially the critical goods and services. This is a really tough thing. This is not it's not a closed system. Canada has to stand as a global citizen amongst nations, and it's a leading nation economically. A big part of that has been foreign direct investment. We could have a really vibrant debate about whether that's for good or for bad, but the reality is, it just is. This is our reality. We have a incredibly vibrant trading relationship, chiefly with the United States of America, our close cousins across the 49th parallel, and with China, a country that we have a fair amount of tension with, and understandably so, given the differences in our political systems. I've cut out a bunch of other key trading partners, but those are the two heavyweights in terms of Canada's economic destiny. We can't practically extricate ourselves from those relationships. It doesn't really even make sense to try. The best we can do is to make sure, as we did in the 1980s, we thought through our economic destiny versus the United States. And now we're in the middle of a reckoning in and around ideas related to whether we can safely do business with China. And if the answer to that is yes, how do we do that? And we're not alone in that struggle. You have our close allies, chiefly the United States, Great Britain, Australia, and I don't want to leave out our friends in New Zealand, trying to figure out how we perpetuate a relationship with countries like China, with whom we don't share certain central key democratic values, while still safeguarding our economic security and outcomes, as well as our national security. And to answer the question you actually posed, we don't define national security, at least for investment purposes in this country. Most of our acts, if not all of our acts of Parliament, will say in the definitional section, here are the key terms. Here's how you are to understand this act as you read it. These words mean the following things. Well, absent from something like the Investment Canada Act is a definition of two key words, national and security. You stick them together, what do you have? No one really knows with concrete certainty. So that's a rule of law problem. It's a really bad rule of law problem. There was a guy who wrote in the 1960s called Lon Fuller, a very famous law professor out of the United States. And he wrote on 8 ways to fail to make law. You're going to forgive me. I don't want to get these wrong. I don't want to misquote someone as important as Lon Fuller. The first way to fail to make law is to produce no rules at all. Well, one could argue that the failure to define key terms means that you don't actually have a rule. National security means what the government needs it to mean on a particular day and hour. When you're representing private law clients, or you are one of those clients, that is a deathly problem. How do you know how to govern your conduct if you don't know what the words mean? I can tell you that when you're in government, the flexibility of having the ability to fill those words with particular meaning as and when needed offers you an incredible flexibility, and it's really important for safeguarding the national security of the country. So we have these values that are in significant tension. The first duty, which is to safeguard the safety and security of Canadians, including Canadian corporate citizens, versus that basic democratic value of rule of law and giving meaning to the words passed into law by our elected representatives. That was a very long answer to what was probably meant to be a short question, but this is the stuff that I lay awake at night thinking about, and now I've shared it with you.
No, I'm glad you have great insights. And to pick up on one thing you said about the lack of a definition, appreciating that it is what the government wants it to be at any given time or period, having regard to a broader geopolitical context, it does create a lot of uncertainty and heartburn for folks on our end who practice in this area in giving advice, to our clients, and for our clients to make decisions with respect to foreign investment into Canada. So it is something that is pervasive right now and would benefit from more clarity, notwithstanding the fact that it's dependent upon perhaps geopolitical considerations at any given time. But you also mentioned our allies, and maybe it's good to segue there into what are Canada's close allies doing regarding investment control? Perhaps what lessons are there for Canada to perhaps learn from these trends or benefit from?
So if you think back to the Trump era, and various people will have various views on whether that is a place to which they want to go in their mind, but it's important to look back and see where we were then versus where we are these relatively few short years later. In the Trump era, Canada was under all kinds of pressure on a national security policy front to do a variety of things, to catch up, to join that leading group of nations who are becoming very hawkish on national security. As you flash forward, Canada not only caught up, it went way out ahead on investment control. So by way of comparison, right now, you have the Americans who brought in legislation called FIRMA in the Trump era, and this was designed to strengthen their review of foreign investment. You had the UK, which brought in an act in 2020 designed to do the same thing. The Australians similarly have been, I think, grappling with their interaction on a trade basis with China for a long time, and they are much up close and personal because of their geography. Each of those countries got tough and then took a step back. The Australians have decided if an investment is below 10%, with certain exceptions, they're not going to touch it. They don't have the resources, the human resources to examine all of those transactions. The Americans, and this is really striking, have permitted, for instance, Chinese battery manufacturers to set up shop in Texas, of all places, that sort of heartland of America. That's where these activities are taking place. Those are establishments on U.S. soil. And the UK has been very transparent. They've said that their 2020 National Security Act went too far. It's not business friendly. It was harming their investment climate. And they actually did consultations asking the business community, including the legal community, how do we make this more friendly so that we continue to attract foreign investment? Canada, by contrast, beginning in 2022 with a trilogy of divestitures in the lithium space, leapt forward. No mercy, very, very rigid in its view of foreign investment. And we could, again, debate whether they made all, some, or none of the right moves on those particular transactions. But it's a little bit like, and I hate to say this, and I'm going to say it to you, it's just the two of us, right? It's a little bit like teaching a teenager to drive. You say, look, you're headed for the ditch. You need to correct. And rather than correcting to the middle of the road, the teenager drives into oncoming traffic, hopefully with no negative outcome. That's not how you drive a car, and it really isn't how you should be making policy. You don't want to overcorrect. So Canada was really far behind its allies. It corrected, then overcorrected. And now Canada has the most restrictive and hawkish view on foreign investment of any of our allies. And some may be listening to this and saying, well, good, finally, we are out front, we are leading. No, we're giving away the investment dollars we need, and we're failing to really capitalize on the very, very skilled security officials that we have in this country who are able to weigh and measure risk and reward. And they're able to administer a system of mitigation that might allow investments while monitoring their implementation in Canada, as the Americans are doing, as the Brits are doing, to render those investments safe. Now, the story doesn't end there, and I think we're probably going to have a further chat about legislative developments. But Canada has, for years, failed to catch up, and when it did, it went too far. And that's a problem for policymakers. It's a problem for the investment community, and it's a problem for Canadians because we still have to build that infrastructure, and we're not getting the FDI that we need.
I'll be teaching a teenager how to drive soon, so I'll be sure to share your insights on that. But I totally appreciate your points about different shifts and backtracking. But let's maybe now focus on the current, right? Because we have recent, not only legislative, but policy changes that are being implemented in Canada, including Bill C-34, which I mentioned at the outset, which is the most comprehensive national security legislation we've had since national security reviews began in 2009. So where do you see national security reviews now going in the coming months, having particular regard to Bill C-34 and other related policy changes?
So I actually think C-34 is a pretty good piece of legislation. It gives and it takes, and I think it does so in appropriate measure. When the bill was first tabled, several of us just across the foreign investment bar spent days poring over it, comparative analysis, trying to create our own bootleg versions of what the final state bill would actually look like. And as we went through this process, there were some pleasant surprises, some flexibility that's been long needed. One of the things the current Investment Canada Act does is it sends investments to the cabinet table not once but twice. And for anyone who's ever worked in Ottawa, going to cabinet is miserable. People who sit at the cabinet table will agree with that proposition. It's very taxing. The meetings are incredibly long. The volume of paper is crushing. The debates are confusing and sometimes unsatisfying. If you can avoid going to the cabinet table by having cabinet put to Parliament a bill that vests a minister, an expert minister supported by expert officials, to make decisions that are appropriate for a minister to make, and avoid these trips to the cabinet table engaging multiple ministers at one time. This is efficient. This is a good thing. And what you see in Bill C-34 is an opportunity for the minister to do a lot more of the heavy lifting. And then ultimately, if a deal is going to be blocked, that it goes appropriately in front of that cabinet body to decide that indeed the investment would be injurious to Canada's national security, however you define that. Bill C-34 has some sharper edges as well. It does increase fines, in certain cases significantly. But one of the biggest innovations is that it moves in sensitive business sectors yet to be defined to prevent notifications of investments after the fact. In other words, it will eliminate this divestiture problem. Divestitures are extremely messy. How do you put the toothpaste back in the tube after a business has been sold. It is really hard to do. The aftermath is very painful. Bill C-34, the new Investment Canada Act, will avoid that by saying in certain sensitive business sectors, you need to tell us, the government, before you implement the investment, before the deal closes, so that we can weigh in. We may impose some interim conditions. And again, the minister will have the authority to impose or at least negotiate with the parties undertakings to make the deal safe. So the hope is that this additional power around undertakings will mean that there's less binary yes and no decisions and more room to negotiate through the lens of national security and the protection of critical infrastructure to get deals done, deals that will be rendered safe and still profitable.
But I guess the devil's in the detail as well when you talk about sensitive sectors. I think our clients need to know that we can expect more pre-closing national security reviews with Bill C-34 than what we had before, just given the statutory regime being built around this. And this notion of the sensitive sectors, like what are these sectors going to be? They aren't defined yet, to my knowledge. And so there's a lot of speculation what they could be, but conceivably it could be broadly defined, which could impact perhaps clients who wouldn't expect to be dealing with national security reviews in the context of a transaction.
So I said a few minutes ago, I lay awake at night worrying about the definition of national security and how it shifts, including overnight. You could wake up and there's a bad news story, and suddenly something you didn't think was sensitive is sensitive, according to the government's evolving definition of national security. By contrast, I'm not that worried about the definition of sensitive business sectors. They're going to come out in regulations. They will be printed in black and white. And we have a pretty good idea already of what they are. We know that they will include critical minerals. We know that they will very likely, almost certainly, include some of the sensitive technology areas that are already in the national security guidelines, things like aerospace technology and advanced sensing technology and quantum technology. So there's, I don't think, going to be any huge shock when those sensitive sectors are published. They will be published in advance so that people like you and I can look at them and have comment on them. But we're also told that there will be a lengthy consultation period with the business community. So government is taking its time, hopefully getting it right. And at the end of the day, because divestitures are so messy, nobody likes them, not the businesses, not the lawyers, and certainly not government. The new Investment Canada Act will avoid the need for divestiture orders in sensitive business sectors. That's a level of certainty that we need because markets thrive on certainty. And this respects what Fuller asked us to do, which is to produce rules that are understandable and do it in advance. It's all that we can ask, and government is in the process of delivering, and that is a good thing.
Well, there's a lot to talk about, Andrew, but we don't have time, unfortunately. So let me just thank you very much for your very insightful comments. A lot of informative discussion here and a lot for our listeners to think about. To learn more about the subject, I invite you to visit our website at fasken.com or to reach out to Andrew or I with any specific questions you might have. Thank you.